This is a moment of truth from the CFP Youth. Today's episode will be a debate hosted by Nathan Bless, Ontario Youth Representative. We will be debating Indigenous land rights must take priority over resource development.
Welcome, everyone. Thank you for all coming. Today we'll be debating Indigenous land rights must take priority over natural resource development. Joshua will be arguing in favor of that. Rob will be arguing against. So this debate will be broken down first into a 3-minute opening speech by Joshua, followed by a 5-minute cross-examination by Rob, which is then followed by a 3-minute opening speech by Rob again, followed by a 5-minute cross-examination by Joshua. This is then followed by a 4-minute rebuttal by Rob and a 4-minute rebuttal by Joshua. After that, we'll have a question period, a short closing from Rob, and a short closing from Joshua. So I'll hand the floor over to Joshua, and he can kick us off.
Perfect. Thank you very much, Nathan. So my opening statement's pretty short. I have 3 major points here to make about why Indigenous land rights need to take priority. The first one is more on an empathetic level. It's their land. It's legally their land. They've owned it for a long time. There's treaties around it. And it's the law to consult Indigenous leaders when it comes to building stuff on their land. And ignoring that is obviously illegal and extremely disrespectful. And it has more of a larger implication around the treaties and social understanding and the whole reconciliation process if the federal government just totally negates that. How would you feel if someone built a pipeline or a mine or some backwater or whatever in your backyard, So on an empathetic level, it's like, hey, man, that's kind of their land to do whatever they want. It's sort of their liberty. And trampling on that is obviously a negative. The second thing is that we're not in a natural resource crisis. We are making record liquid natural gas, record copper, record iron. And so there really is no need for some wartime emergency powers to sort of supersede the treaties around resource and land use. And the third point kind of comes back to the first one. It's the law to consult Indigenous groups and leaders with respect to using their land for natural resource. And that specific law you can find on the Government of Canada website. You can literally just Google Government of Canada and the duty to consult. And on the whole page, it sort of breaks it all down. And there is precedent for this to happen as well, affirmed by the Supreme Court of Canada. And those are my 3 points, and that's my opening statement.
All right, cross-examination by Rob.
Perfect. I'll start with a few questions. I saw that you brought up the constitutional protections here at play, but Are you aware that the Constitution protects Indigenous rights but allows for justified limitations in public interest?
Yeah, 100%. But it's not justified because there's no natural resource crisis. We're making more than we literally ever have, and we're on track to continue that trend for the next 10 to 15 years.
Absolutely. I think along with that, though, the statement taking priority, it asserts that there is absolute priority, absolute ownership, which, the law has been tested multiple times to state that is not the case.
That's wrong.
So I think that taking priority does not align with the Supreme Court's duty to consult and accommodate. I think that there's a difference between accommodation and taking priority, and I think that we need to address the difference between those two things. So in your opinion, what is the difference between accommodation and taking priority?
Well, I'll refute the central point there that it isn't their land and that it isn't the main point or the central function, because they own that land on a legal basis via all the various treaties. And in the government's own law, they have to consult Indigenous groups. I read through the whole thing. It's not we can kind of choose if we want to or not. Or there's processes to go to war. There's processes to fund public projects. There's steps and processes to things. And when it comes to building things over large stretches of land, usually those will encounter Indigenous land. And part of the process if you want to build these pipelines and these mines and all these other various bits and bobs, you got to go through the process. And if you kind of throw that to the wayside, kind of allows the government to throw other processes to the wayside, like right to a fair trial, not presuming innocence in court cases. So it's a pretty slippery slope.
Would you agree that consultation is akin to negotiation?
Well, it depends on the scenario. I mean, the way I view it is hey, we want to build this on your land. What can we do to negate, environmental impacts? Are you even okay with it being there? And what can we do to figure out a way to make this happen.
Okay, so if you're okay with consultation and negotiation, then I think that supports the fact that there shouldn't be a precedence taken by one side. One side should not get exclusivity either way, right? We're talking about a negotiation, and we're talking about partnerships between the government and Indigenous nations. So I do want to address priority here. What about a case where one Indigenous nation prohibits an action, but another one supports it? Who then gets priority?
Well, I'll take it back. What if it was just like anybody else's private land, right? What if it was your family ranch or my family ranch or whomever else's? It wasn't just an Indigenous piece of land, it was individual ownership.
I'll address that in my cross. I'll address that in my cross for sure.
Will that change though? Would the consultation have to change? Because it is private land, so it doesn't really matter who we're talking about here. It's just private land in general.
Constitutional land claims are very different than private ownership, even in Canadian law. So according to a Canadian law, the private ownership of land is a completely separate protection than constitutional land claims by any certain groups, because there's a difference between individual private ownership of property versus a public group ownership of land.
Perfect, thank you. And yeah, I do, because again, it's kind of their process in the law when it comes to their development of land. So they kind of wrote their own rules, and they got to follow them.
I think that kind of addresses all of my cross. Let me see here. I think we only got 8 seconds. So
all right, thanks for that. So now we can continue with Rob, and he can give a 3-minute opening speech.
So I will rise today not to diminish Indigenous land rights, but to challenge the idea that they must take priority over natural resource development. This motion asks us to choose one side of the complex equation on what Canada truly needs is a balance, a way to honor Indigenous land rights and peoples while ensuring that our nation can grow, provide, and prosper for generations to come. Indigenous land rights are protected under Section 35 of the Constitution. They are fundamental and they must always be respected. But even our highest courts recognize that these rights exist within a framework of shared responsibility, a duty to consult, to accommodate, and when necessary, to find compromise that serves the greater public good. Canada is not a collection of competing sovereignties. It is a federation of peoples, Indigenous and non-Indigenous, bound together by mutual dependence. Natural resource development is not just an economic talking point. It is one of the foundations of Canadian life. The resource sector contributes nearly 1/5 of our GDP and supports hundreds of thousands of jobs, 900,000 plus. In taxes and royalties, it generates funds that service Canadians, or fund all of the services, more or less, that Canadians rely on, including Indigenous Canadians. Those are hospitals, clean energy projects, infrastructure in remote Indigenous communities. When we talk about development, we're talking about healthcare for children, roads that connect communities, and revenues that sustains our shared future. Many Indigenous nations understand better than anybody across Canada. First Nations, Inuit, Métis communities are not just participants. They are leaders in these developments. They are equity partners in pipelines, in hydroelectric facilities, in critical mineral projects. Through these ventures, they are creating jobs themselves, training programs and revenue streams that strengthen self-governance and reduce dependency on government transfers. To say that land rights must always take priority risks taking away that choice, and it replaces the freedom to lead with one's power to veto.
Thank you, Rob. Now we can shift to Joshua, and he can have a 5-minute cross-examination.
So when we say takes priority, Robert, how would you define takes priority? Do you mean the Indigenous folks don't need to be consulted, or that there should be a consultation process, or should it be like a forced hand sort of endeavor?
I believe that the current system of consultation and accommodation is sufficient. So when I hear takes priority, to me, it sounds like an absolutist, exclusive policy. It sounds like Indigenous communities want a final hand and an ultimate veto over all of these projects, regardless of their impact. And so that's why I do oppose something taking priority over another, especially, in this case here, we're talking about 5% of the population compared to 100% of everybody who gets benefits from these resource projects.
Cool. So 2 subpoints to that, and you'll forgive my goldfish brain. How much of Canada is claimed Indigenous land under the constitutional protection? Do you know? I should have Googled that beforehand.
I also don't have that answer, if I'm being perfectly honest.
Are we able to just quickly pause so we can figure that out for a quick second?
Absolutely. We can take a very brief pause.
I'm seeing very different numbers. I don't know if you are as well. The numbers I'm seeing range from anywhere from 0.2% to 40%, which is like, how can those
Yeah,
reconcile?
that's a lot. 0.2 to
Oh,
40 is quite a bit. So let's call it 25, 20 or
sure.
25. 25% of Canada's land is under the oddly average, the mean,
Yeah.
based on our very brief research, is under Indigenous land claim. And so far, a lot of Canada's natural resource projects have been able to succeed under that, right? So I'm not seeing why, in your statement as well, the current system is pretty sufficient. And given that the current system includes the duty to consult and that there's a large possibility, and I don't know if there's a total veto of Indigenous groups to end or stop or pause the development of these projects. So the current system already works pretty well. They already have a fair amount of leverage when it comes to pausing or vetoing these projects. And in terms of reconciliation, it's really, really important that we keep this, right? So I tried to get as many of your statement down as possible. And if we want to always respect Indigenous people and their land claims based on the Constitution, then we should continue to keep this vetoing process and this consultation process intact. Additionally, one of your comments of everybody always prospers from this. One of Carney's big country building projects is the Kilimat LNG port and pipeline. The BC Chiefs Union voted and released a statement wholeheartedly opposing that project. And all the major stakeholders in that project are non-Canadian companies. So what is your response to that?
I would need to look into that particular project further. I do think that it is a problem that project is owned by non-Canadian stakeholders. I think that that's something that needs to be reviewed and rectified, and it's not something that the government should be doing. Mm-hmm. But I do think that we have some agreement here, and I think that we may just be looking at two different perspectives. I think my biggest takeaway here is that I think that there should not be a veto. I agree with you that this should be a negotiation, and it should be a consultation, and there should be accommodation. I agree with all of those things. I do not agree that either side should have a veto. And right now, because of the way that it's handled through the judicial system, which is separate from our executive branch, I think that both sides currently do not have a veto, and that's the way it should maintain. And I think that the argument that Indigenous rights should take precedence argues that they should have a veto, and that's what I oppose.
Cool. And in the last 20 seconds here, I'll make my question quick. Would you support a definition of a veto that would force companies and Indigenous groups to fall back to the negotiating table indefinitely until a solution is resolved?
I would definitely think that maintaining negotiations until a resolution is found is better than one side having an ultimate veto. Yes.
Okay, cool. Thank you very much.
All right. Thank you very much. Next, we will move to a 4-minute rebuttal by Rob.
So I think addressing Joshua's main points here, I think that we are finding actually some common ground. I think that we both agree that Indigenous rights must be protected. I think that we both support the fact that Indigenous rights must be protected. I think where there is some difference is in the ultimate power and who should hold ultimate power in these decisions. And I personally believe that ultimate power needs to rely on our judicial branch, as I believe it currently does, and that they should be, like in all other situations in Canada, they should be the final say as to which side has a stronger claim to the situation. So if we're talking about resource development, if let's say a pipeline is being proposed to be built through Indigenous land and Indigenous leaders are opposing it, I think that the judicial branch, it's their job to look at the claims on both sides and determine if there is need. If there is need, then I think that the Indigenous claims may be superseded. But if there is not need, I don't think that they should be forced either. So I do believe that the judicial branch is where the ultimate power in these decisions should rest. And I don't think that it is beneficial to provide this ultimate power to either side, because I think that would increase exclusivity and it would increase competition and add more fragmentation to Canadian society, which is not what we need. We need further partnerships. And further to that, I would support Indigenous communities taking a stronger role in participating and even leading in these resource development projects, especially when Indigenous land is involved.
So we're at the
4-minute rebuttal from you now, Joshua.
So I will agree with you, Rob, to a certain degree on having the judicial system be sort of the backstop when it comes to resolving these crises. At the end of the day, I wrote down constitution over capitalism. What I mean by that is we need to respect their land rights and what their opinions are around what should and shouldn't be developed on their land over what would make Canada, or in this case, and a lot of, at least in Kilimat and probably other projects, the stakeholders of those projects. So it's not unheard of for judicial systems to be influenced through economic development or economic prosperity. And I think that the veto, in my opinion, would be best described as the ability to put a pin in whatever project is in, a contention, and take the designs and all the other things back to the drawing board to figure out how this project can exist on their land. Also, the judicial system determining need and taking it back to the drawing board also includes court hearings around what the project is about and the need, which goes into my next point of what is the need. I mean, again, we're producing more natural resources than we ever had. And again, we don't need emergency powers to increase our oil production to fuel our tanks and planes or whatever. So we have a chance here to respect and increase Indigenous land rights while we're also already making records amount of money. So we have a chance to increase the rights and power that Indigenous people have while we're already making a whole ton of money. So there isn't really a whole lot of need to go through these crazy loopholes to get these projects done. And the other point is Indigenous leadership in resource development. Is that a payday or is that a partnership? Are they taking royalties off what's produced on their land, or are they owning the companies and running the companies that are producing these products? So that's an important part because, in my understanding, at least based off the few articles that I read, in Kilimat, BC, the Indigenous groups there take a payday off of the royalties or at least some form of the LNG exports, right? And so, I mean, I think we could all be influenced, everybody, no matter who you are or where you could come from, by financial gain. So economic development shouldn't supersede Indigenous rights. Economic development shouldn't supersede ecological sustainability. And, LNG, Carney's posing it as a trade-off for coal or something cleaner than coal, but nowhere in any of his documentation, when we're selling these to other new countries to get them off the coal, there's no sort of plan to get them off of our LNG, right? So if we're going to pose this as something that's beneficial for Indigenous people, beneficial for the environment, beneficial for local ecology, we need thorough plans, and we have the opportunity here to increase and respect Indigenous land rights, which I think we should take. So the veto would look like a pause or a pin or something along those lines to take the plans back to the drawing board and to court to figure out what would be the best way to do things in both views.
Nathan, if we don't mind, before the question section, could I address some of those? Because there's a few talking points in there that I think were brought up initially that I'd like to just talk about quickly.
Yeah, sure, go crazy.
Yes. So a few I want to talk about is we've hyper-focused a lot on this debate so far about oil and LNG. And I think that those are only some of the projects that are covered kind of in these debates. And I think part of it is crucial minerals and crucial resources on the nickel, cobalt side of things. And a lot of those crucial resources are required to build green energy projects. And so a lot of the time, if we're talking about wanting to transition to a green energy society, especially, I know a lot of Indigenous leaders are pushing for that. A lot of the time we need to mine the minerals in Indigenous land areas to create the actual technologies required to do those green energies. So I think that that's a big part of the debate. I think we may have missed out on, but I think is important to talk about. And I think the other side is if we're putting the pin in a lot of our energy projects, I know right now there's certain metrics that say that we're meeting all of our goals, but that's not actually true because we import a lot of energy. As a country, we might produce a lot of energy, but we also import a lot of energy. And if we're putting a pin in our energy production projects, it's going to force us eventually to import energy from nations who have worse standards for the economy, for the environment than we do. And so if we're putting pins in our projects here at home because we don't want to create environmental concerns, and then importing energy from countries that have worse environmental practices than we are we actually making the benefit that we think we are, or is it just a it is just a front of a battery.
I did really focus a lot on the LNG and oil part, but I haven't forgotten about the critical minerals. To your point of, if we put a pin in oil and gas here and we start exporting or importing it from place B, who has significantly worse standards, which most of the world does, Canada leads the world in terms of ESG mining. There's a reason why Canada is the place people go to start mining, because nobody does it better than we do. I feel like there are other options when it comes to importing or finding or using different energy sources to get our electrical requirements and fuel requirements. And as much as I really would hate to deal with the US in this time and place in the universe, and also like generally in the past, we already do import a lot of electricity from them. So if it really did become a genuine electricity and oil and gas crisis, that would be the geographically closest option and probably the less technically complex one. So there are more options on the suite of things that the minister of whatever can do to try and uphold the energy requirements. There are more options on the table than importing it from, some third world or developing country that doesn't have the mining and extraction and human rights enforcements that we do. In terms of mining for critical minerals that will increase our ability to transition our global economy to green things, I'll use the DRC, the Democratic Republic of the Congo, as an example. They mine a huge amount of cobalt and other various elements that are used in battery technology. But they also have one of the highest rates of slavery in the world. Yeah, fine, they're selling their mostly illegally mined, and they do have laws against it, but it still happens anyway. So they are selling their minerals to build batteries for various companies, but it's literally done by slavery. So we shouldn't be doing things in a morally negative way to justify something as morally positive. Like, you can do the right things for the wrong reasons. The right thing would be getting more cobalt into the market, and the wrong reasons is using slavery and just making a buck. You know what I'm saying? So we shouldn't put the green transition or any other sort of positive end goal over the means of how we do it.
I will add that the argument is that we're mining Canadian minerals, and that if we're not able to complete projects on Indigenous land because Indigenous groups are vetoing these projects, then we would be forced to buy minerals from countries like the Democratic Republic of the Congo.
Well, that would assume that every single project and every single mine everywhere was vetoed. Like, it would mean that we would have to discuss whether all of the mines and pipelines in Canada would immediately be suspended versus just new ones. So I have a hard time seeing a reality where every single mine and every single pipeline is vetoed and suspended. Like, that's completely off the table, and for so many different reasons. I'm more focusing on the new projects. And I have a hard time seeing that becoming a reality, but it is a fear. It's a great concern because we didn't clarify it. So thank you for bringing that up.
What about a project like I had mentioned, like where two Indigenous groups might not agree? Like, what about a project that starts in Alberta, that's some sort of energy extraction project, and the Alberta Indigenous community want this project, but it needs to run through, let's say, BC or another province to actually export efficiently. Okay. So who in that case, which groups have the stronger claim?
My initial knee-jerk reflex reaction to that is they would have equal claim because it runs through all of their land. The counterpoint immediately to that would be is the oil starts in Alberta, but only snakes through BC. The folks in Alberta are more involved in the actual process than the folks in BC. But if we're talking strictly land right claim, I would vote for them being of equal power and sway and influence. Neither group would have the ability to supersede the other on a strictly land claim basis.
So would a project in that case be stalled into infinity because one couldn't, Alberta couldn't complete their project without BC's approval? You know what I mean? It becomes a circular thing.
Yeah, and I think that's probably where the judicial system would probably step in. I think if there wasn't a resolution decided upon within a specific set amount of time, or even before that, if one group's like, hey, let's just take it to court instead of arguing across the dinner table or whatever, that's probably where the judicial system would come in, and they'd probably sue each other or however the heck it would work. And federal judge would have to go through that, because it goes through obviously 2 provinces, but it probably should go to federal judge anyway, or maybe a provincial. I'm not quite too sure, but it would definitely be taken to the judicial system in that case.
But I think taking it back to our argument here, if any Indigenous group has a veto over their land, I don't think that there is a way for this to go to court in that world, because in that world, the BC side has an infinite veto. There's no court that can say that Alberta's claim is strong enough to break BC's veto, because the federal government can't break that veto. Why should an Alberta Indigenous group be able to break that veto? So that's where coming back to kind of my opening statement. I just don't think that veto should exist to anybody, because it opens up too many scenarios where you're giving the defensive side infinite power. So you can never have any sort of progressive movement in that case, because any defensive side can immediately shut down everything with no recourse.
I feel like those are all valid points. It boils down to what the priority is in terms of, like, what are we going to uphold more, but also the definition of the veto. When I initially heard it, I was like, my initial reaction was veto means this isn't going to get built, and we're going to take it back to the drawing board, or figure out how it either isn't going to go through our land or it can with certain conditions. You know what I mean? So it's not some oil company or some mining companies can say, hey, by the way, we're going to build this on our land and that's our consultation. It's like, hey, is this okay? If it isn't, how can we make it okay? And if it's not okay in the slightest, then I guess there's probably a whole infinite different, spider webs off of that. So when I thought of veto, I meant like an Indigenous nation that was in question and whatever project was on their land didn't like that. It was this isn't going to get built, and we're going to figure out how it can be, or whether the company in question is going to figure out a different way to circumvent the land. But this whole argument also kind of pins off of that. Every Indigenous nation, at least the vibe of this conversation, feels like every Indigenous nation is going to veto it. There might be some company that puts forward a very well thought together, very comprehensive plan that the Indigenous nation's like, hey, that's actually kind of dope. We like that a lot. Go crazy. Go ahead. And we're all thinking of this like doomsday scenario in like infinite circles of we're going to block, and then we're going to say yes, but then we're going to block it again. And that's, I feel, where the judicial, consultation and steps would probably take in.
I think my counterpoint to that is, in a system where that veto exists, I don't think you're going to have any companies coming to Canada trying to build those projects. If I were $1 billion company, especially an oil or a precious minerals company, I'm not going to try and build a $500 million project somewhere and do all of the pre-planning work if I know that somebody along that line has an infinite veto that I have no legal way to even have a negotiation about. I think that that's going to absolutely stifle all of these projects going forward if anyone has this veto. And I think that that's why the Canadian government has made the decision not to provide anybody with this veto, and even wrote into the Constitution that nobody has an infinite veto on either side, and that there is justification that's able to break current land claims. And I think I think it was constitutionally built that way to allow for business to maintain, because like I said, if one side had the veto, I think that would incredibly stifle business.
You could always just build around it, there are, if you're driving on a road and there's like tire on the road, you're going to drive around the tire, right? But also, what are we putting priority to? Are we putting priority to making money and developing resources, or are we putting priority to respecting land rights? It's very clearly elaborated this. At the end of the day, if there are no ways that the company in question or the land groups or Indigenous groups who claim the land or whatever can come to a resolution, that's when the judicial system would be able to break that. So it's like, and that's when we go to, what do we define as like, this needs to go through someone's land? We don't need a whole lot more oil. We don't need a whole lot more LNG. We definitely do need a whole lot of critical minerals to build batteries and all those sorts of fun things. But again, we're already producing record numbers for the planet killing resources, and we're probably not producing a lot of the critical minerals we need. But then there's also like, we need to protect the environment. We need to make sure that, in my opinion, the companies who are benefiting and profiting off of these major capital projects are Canadian companies.
I agree with that 100%.
So when I think of veto, I think of this isn't going to happen, and let's figure out a way so that it can happen. And if there isn't really any way, then just build around it. You know what I mean? Or figure something else out.
That to
So
me, though, doesn't sound like a veto. It sounds like a negotiation, which is
yeah,
what we have.
veto,
That's where I think consultation meets that.
veto consult. Like, I mean, I think veto is the accurate term to the extent of this project isn't going to happen, but it doesn't follow. It doesn't really counter make sense past that to the point of let's figure out how it can. You know what I mean? So it's like a veto consultation. Or
Well,
like
I think that's where
redesign.
that's where accommodation. So right, it's the mix of consultation and accommodation. So I think that second part is where the accommodation side of the Constitution comes into play.
I think that Indigenous groups should and have and do and potentially increase, but that would be subject to, well, I guess this debate. Figure out and discuss the things that happened on their land.
All right. With that, we'll move to the closing statements, starting with Rob. You have 3 minutes.
So in closing, I think that the key article of this debate is about the power of veto, and if that power of veto should be removed from the judicial system and moved to any group, whether or not it's the federal government or Indigenous communities or a body of homogenous Indigenous communities, some sort of hypothetical one. And I think that my opposition is to that veto being moved. I think that veto should remain in the judicial system like it does for every other decision in Canada. I think that there's a reason why it was constitutionally built that way. I think that it was built with the idea of consultation, accommodation in mind, so that projects do need to be brought to Indigenous leaders. Indigenous leaders should be participants as well as members of these projects. If they want to, they should be leaders of these projects. If anything, if they should, maybe promote these projects on their own lands themselves so that they can run the companies that do these projects. But I think that they should not be able to ultimately veto in a case where there is justified need. So if we were facing a shortage of any sort of need, whether it's oil or it's nickel or it's cobalt or it's LNG, I don't think that any group should have the power to veto a project that supports that. And so I think that providing that power to any one group is a mistake, and that's why I oppose it. That's the end of my closing statement.
Joshua, you now have 3 minutes for your closing statement.
My argument is that Indigenous groups should have a veto to an extent that the projects should not be and will not be built until their conditions are met, full stop. Whether there's an agreement on whether those conditions can be met, can and should and probably would be resolved in court, which is totally fine, but no development or building on their land should happen until they have, where the companies have consent. I agree with a lot of what Rob says. No group should have like the absolute veto power, but they should have the veto power until their consent is achieved. How we decide how the veto gets voted on or built is obviously still needs to be debated upon. What we take priority of, making money or protecting land rights, is also very important. I'm obviously on the side of protecting land rights, and I think everyone else here is as well. And maintaining the fact that, it's the law to consult these groups and Indigenous people around the use of their land. So in saying that, we've sort of painted a slightly doomsday scenario of every single group is going to veto every single project. I don't think that's going to happen. I don't think it's even reasonable for every, Indigenous group to veto every single project that's already happened. I think this should only apply to new projects, because redoing all the ones that already exist is going to be so expensive and way too technically complex. And we're not in a shortage of any resource. We are producing record levels of basically everything. So there isn't really any need to veto on either side to force these projects into existence. So we have an opportunity here to maintain their rights, increase Indigenous decision-making in Canada. And I think that's a net positive for everybody. And that's the end of my statement.
Great. Thank you to both Joshua and Robert for the debate. Our next one will be on lowering the corporate tax rate. Great.
Thank you for watching this debate from the CFP Youth. Please like and subscribe for more, and come chat with us on Discord.